So our goal for all things neuro is to be a one-stop shop for anything related to the brain. So we're not just one company, but we're a group of different specialists and different companies that come together to provide a comprehensive solution on the neurological side. So we have board certified neurologists, we have psychologists, neuropsychologists, speech language therapists, functional neurologists, PTs, and psychiatrists that we all work together as a continuity of care for your needs. If everyone could just mute
Yeah.
yourself real quick, that would be amazing. Otherwise, I will mute you as soon as I get off of this screen. So our goal is to help not just on the traumatic brain injury side, but also the mental health side, which is related to brain injuries. And so we can be comprehensive. So just to touch on this, we can do the testing. We've got the mental health side. We've got the treatment side for concussion rehabilitation. And then with people like Dr. Barnett and Chris Connelly, we can also offer IMEs, impairment ratings, life care plans, and forensic analysis, which is this is really what I think is going to be touched on when it comes to this topic of conversation in terms of how we're going to play this out. So just want to mention that if you have any need for that, hope you will consider us as your solution. And then I'm going to stop sharing my screen here and introduce Chris. Let me see who else might be. I see some people taking notes with their AI, which is amazing. Like, we've come a long way on technology, which is fantastic. So let me introduce Chris. Again, I'm going to mute everybody, and then I'll ask you, Chris, to unmute yourself when I make you host. Okay, you can hear me, right?
Yes.
Okay. Am I an echo on your side or just my side?
That's good. No echo.
Okay, so Dr. Chris Connelly is obviously a highly respected chiropractor based in Stone Mountain, over 26 years of clinical experience. He specializes in treating trauma-related injuries, including auto accidents, sports injuries, and work-related injuries. He's managed over 25,000 trauma cases and conducted more than 400 patients throughout his career. That's amazing. That's a lot of people. He earned his
27 years.
doctorate of chiropractic at Life University. He's a certified brain injury specialist from the Brain Injury Association of America. He's a certified impairment rater from the International Academy of Independent Medical Evaluators. He's certified chiropractic sports medicine specialist, certified in concussion testing with BrainScope, CDC certified in concussion awareness. And he's also a certified chiropractic insurance consultant, has completed training in the AMA Guides to Impairment 6th edition. In 2019, he was honored as Chiropractic of the Year by the Georgia Chiropractic Association. He served on their board of directors from 2014 to 2017. And he's been recognized as an expert witness in legal cases, having provided second opinions and impairment evaluations in over 2,000 cases. He's also taught more than 50 seminars on topics such as injury causation, MRI interpretation, and patient care. So with that, I'm going to turn it over to Chris, and I'm going to make you the host so that you can take it away.
Thank you. Let's see. And I need to share my screen so I can. Perfect. And can everybody see this? Okay, you can see it. Perfect. Well, thank you for the introduction. And again, my name is Chris Conley, and I've been a chiropractor for 27 years. I would like to thank All Things Neuro and also the Academy. And Dr. Barnett is here, and he was actually just elected president of the Academy. So we're very happy to have him be president. But also, it's important that this is not legal advice. It's always important to consult an attorney about all of this. This is just information for chiropractors about the new tort laws. There's been a lot of information, misinformation, and so we're diving deep into Section 7, which is the one that applies most to us. Also, Dr. Alpert is a partner with me with Pain Free Atlanta. So anyone who wants to know more about Pain Free Atlanta could talk to Dr. Alpert. That's his phone number right there. Also, that's my cell number. Reach out with any questions, problems, anything I could help with. But we're going to dive deep into it because we have a lot of information to cover. So first of all, in the state of Georgia, chiropractors, it's called a peer review agent law. So there's a certain number of chiropractors in the state accepted by the board to talk about what is in the scope of practice, what's usual, what's reasonable, what's customary, and testify in court to say, okay, these bills and codes meet the criteria for payment and these bills don't. So I'm one of a few providers in the state that is accepted by the Board of Examiners as a chiropractic review agent and have testified in court about scope of practice, what's in the scope of practice of chiropractic, but also billing, coding, what's usual, reasonable, and customary. And so that's what we're going to talk a lot today about, usual, reasonable, and customary. But again, this is for education purposes. Each case is individual and separate, so it's always important to reach out to people about individual cases, but also to a healthcare attorney for your own special needs. So the healthcare bill that was just passed was very vast, lots of information, lots of topics covering a wide range of things for attorneys. The thing that really focuses most for chiropractors and medical providers and injury attorneys are the phantom bill or phantom damages section, which is section 7. So typically in the past, you'd see big bills, deep discounts. So some providers would come in there and just do crazy fees, but understand that they're going to accept 10% or they set their fee schedule up like that. And that the philosophy was big bills, deep discounts. And that's what phantom damages was meant to target, were the specials that were inflated so much and presented to the jury that the jury, was awarding improper amounts because of the fact that they thought the specials maybe were 100,000, but in reality they were 25,000. So that was sort of the spirit of this bill. I think it could have been done a little bit differently. There's a lot of language, as we're going to cover today, that's sort of misleading and I think could have done a lot more clearly. But that's what we're going to focus today on is section 7, which deals with phantom damages. We're also going to go over today about, are you contracted with the health insurance? Is it better to be not contracted or contracted? And if you're contracted, see patients like you would normally. So if they have health insurance and it's a motor vehicle collision and they present the health insurance, use the health insurance because you're contracted to do that. If you're not contracted, then it's a different scenario. We're also going to talk about workers' compensation fees, usual, reasonable, customary, something called a deferred agreement to pay versus a letter of protection or a lien, and also non-economic damages. So again, we're going to focus on section 7, which is the technical bill. What does the bill say? What doesn't it say? And sort of go through different sections of the bill. But also I'm going to cover usual, reasonable, customary as defined by the American Medical Association. The American Medical Association has a policy concerning what this is with definitions on usual, reasonable, customary. And as an expert who's testified what is usual, reasonable, customary, this is something that we rely on. So we're going to dive deep into what does the bill say in section 7, and also what does the literature say as far as what is medically reasonable for usual, reasonable, customary. But it is interesting to look at both of them individually. So the first part of the bill, and again, we're dealing with section 7, is you have economic damages and non-economic damages. And in the past, it's been focused mostly on economic damages. The specials are 35,000, policies 25,000, rather than what are the non-economic damages. And so I think you're going to see a lot more emphasis on patient care. What's the tissue damage diagnosis? What is the mechanism of injury? You're going to see a lot more diving into more specialized and expert witnesses coming in to talk about cases. And there's going to be a need for that because it's no longer just artificially inflate the bills and hope the jury gives a big verdict. So they are going to have to sort of come in a little bit more fair with the numbers, but there's going to be more emphasis on economic damages and non-economic damage. So economic damages are the past, future medical expenses and past and future lost wages. Non-economic damages are very important, often don't even get addressed, but they're very, very important. So you have the past and future pain and suffering, mental suffering, loss of enjoyment, disfigurement, physical impairment, anxiety, humiliation, emotional distress. So non-economic damages are usually focused on in impairment ratings. Also in life care plans often can address these as well. But there's going to be an emphasis not just solely focusing on the economic damages, but also discussing the non-economic damage, and also to go deeper into the tissue damage injury causation, dive deep into more of like what is actually proven to be from that collision. And when you're talking about serious injury and you're talking about people who have continued pain, it could be brain injury, it could be herniated disc, facet syndrome, things that need surgery, broken bones, things like that. This is sort of a nice framework to look about serious injury. First of all, what are the signs and symptoms? If it's something that is a very serious injury, you would expect the signs and symptoms to be close to the trauma. So you're not going to see someone with a broken bone have the broken bone found out 3 months later. So typically, the earlier the onset of the symptoms, the more severe symptoms at the beginning, does the mechanism of injury make place? You look for the signs and symptoms at the beginning. Is the diagnosis and the testing, is that congruent with the signs and symptoms? Is the treatment or recommended care based on traditional standards? Is it based on the ODG guidelines or professional guidelines? At a certain point, then you would do an impairment rating, which also includes causation examination and disability examination. And then later on, you talk about life care planning and future damages. But one thing that's really important to talk about impairment ratings is that also you talk about the future damages. So with brain injury, it could be the beginning stages of dementia. With interarticular joint damage, such as with facet syndrome, which is a synovial joint, you could also talk about the incidence of long-term post-traumatic arthritis. So not only do you talk about the loss, what's been taken away, but also you talk about what are the future consequences of these injuries. But these are considered non-economic damages, but it's important to say things must be logical. You don't want to do things that are outside of the normal scope. And I think my screen just went away, Jen. Let's see.
Chris, I don't know if you maxed out, but I do have people texting me that can't get in. I don't know if your assistant there can let them in or something, but.
Sorry, I was trying to not interrupt, but also get over there so I can let people in. Can you try one more time? I think I might have allowed you to share.
Perfect. Can everybody see it again? Perfect. All right, good. So again, an impairment summary, it's to validate or confirm the diagnosis. Recommend additional care. Sometimes people, they come for impairment ratings and they don't really have an accurate diagnosis. So sometimes it's a help them get the accurate diagnosis. I see brain injuries missed in a lot of cases, PTSD and anxiety is missed. I see a lot of people that they have bulging discs and they have epidurals, but in reality, it's facet syndrome. So part of it is to validate and confirm the diagnosis. What is reasonable for a trauma like this? Determine injury causation is part of the impairment rating. Determine the loss, what's been taken away. What are the functional disabilities? And what's a natural history of the disease process? What's likely to follow down the road? So if patients have brain injury, what does it look like 5 years from now? If they have a moderate to severe brain injury, it's not very good. It typically could be death or early death. In fact, even with mild brain injury, the AMA put a paper out last year talking about how even with mild brain injury over a 30-year period, there's a significant reduction in death. So statistically significant. So even though it was mild over 30 years, they actually had a reduction in their lifespan. So you want to talk about the future problems they may have because of these injuries. So now we're going to get more into, the section 7. And again, just like Mike talked about, it is going to open the door to having more experts, more explanations, better reporting, better documentation. But basically, for special damages and healthcare expenses shall be limited to reasonable value of medical necessity and care, treatment, and services in the amount of such specials that are determined by the trier of fact. So it's going to be, there's a lot more emphasis on the juries to decide things, but also the attorneys to present things, and also for the providers to document things. So it is important to have good documentation. So that's where section 7 starts into. And then the part we're going to really dive deep into is section C, which talks about private and public health insurance and workers' compensation programs. And this is the one that sort of has had a lot of attention, and there's a lot of wording in here that, I would rather not be in here, but also it is in there. So we just got to do with it what we can. But basically, this talks about anyone who has an injury and they have public or private healthcare insurance or workers' compensation, that basically for past, present, and future medical or healthcare expenses, the amounts actually necessary to satisfy the charges pursuant to the insurance contract or the application of government workers' compensation program, regardless if they use it or not, in the now, future, and the past. So it doesn't matter if they use it. Basically, they're going to reprice the bills according to those contracts. And so this is one of the sections that really had a lot of attention. And again, the wording, there's a lot of problems with the wording, but also it talks about if they have health insurance, even if they don't want to use it, even if they didn't use it, that they may still be able to reprice these into what's presented to the jury. Now, one thing is if you accept health insurance and they present you with health insurance and you normally would accept it for normal patients, I would accept it because that's what you're doing. I wouldn't just automatically have a policy to say, look, it's PI, I'm not going to accept health insurance. But if you normally would accept it for one patient, you should accept it for all patients. So you need to make that decision. But also, this is something where we're going to dive deeper into this section because there's a lot of information in here. So first of all, the part it talks about with to satisfy charges pursuant to the insurance contract. One thing that's interesting is that Medicare actually has a document and a form that you could fill out to opt out of having a patient use Medicare. So if you're a member of insurance and you have a contract with them, there are methods that are contractually within the agreements of some of the policies, a process to be able to opt out of these with the patients. But it is something, again, if you normally accept it, it's a good policy just to continue to accept it, because if you accept it normally, then you should accept it for these injury cases as well. But also workers' compensation. What are the workers' compensation programs? And we're going to get into some more things about workers' compensation in a second, but it's important to note that Medicare actually has an opt-out form, and you can find this readily available online, or talk to Jen at All Things Neuro, or give me a call and I can help you get this form. But for workers' compensation, it's a different animal. So workers' compensation, there's a fee schedule, but also payment needs to be made in 30 days. After 30 days, if payment's not made, then there's interest that has to be paid as well. So it's important that these are fee schedules meant to be for workers' compensation patients, but this part of the statute says that it also could be applied for personal injury cases. But again, it's like comparing apples to oranges. So this is an important part down here where it says nothing in the fee schedule precludes a medical provider of goods and services from entering into a separate contract that governs the fees. Okay? Nothing in this fee schedule precludes the medical provider of goods and services from entering into a separate contract for governing the fees. This is very common what you see in some of the health contracts as well, but this is something where you can have a contract to be able to say, look, this is something where we're going to provide care and get paid at a later date. So with workers' compensation, you provide services, you get paid in 30 days. After 30 days, if you don't get paid, then there's interest that applies. We're going to go over that interest in a second. But also there is a process to dispute fees. So if you charge something and you send it to workers' compensation and you don't feel that that's appropriate, you could actually appeal with the board and they will have it reviewed by a peer review agent. I thought it was interesting in the statute, it talks about the peer review organizations accepted by the boards are include the Georgia Chiropractic Association for Chiropractors. So it is something where there is a process for appeals. And that's, I think, something not covered in the statute of 7C is the fact that, yes, there's contracts, but those contracts also have exclusions saying that you don't have to specifically take that fee. You could actually negotiate individually with the patient for a different fee schedule. But also in the field of workers' compensation, there's penalties to be paid if it's not paid within a certain period of time. So this is that statute I was talking about for late payments. So if they wait more than 30 days, between 30 to 60 days, there's a 10% fee. If they wait between 60 to 90 days, there's a 20% fee. If it's over 90 days, it's a 20% penalty plus 12% interest per year. Okay, so these are things that, say that there's a workers' compensation, you didn't know it was workers' compensation, but basically they're valuing it as workers' compensation. These are things that the contract or the law basically allows for, saying, well, look, if you're using this fee schedule and if it was paid at the time of service, that's one thing, but also it's 3 years from the date of service. So these, by statute, these late fees and the interest fees would apply. It's also Georgia law that does not mandate providers to accept insurance plans or be part of specific networks. We have something called the Georgia Any Willing Provider Law. So healthcare contracts are an individual thing that providers decide whether they're a member of or not, depending on each circumstance. I'm not a member of any health insurance. I don't have any contracts with any health insurance companies. Some providers may, depending on their circumstance, and that's fine. That's their prerogative. Now, Section 4507 of the 1994 Balanced Budget Act also allows physicians and practitioners to enter private contracts with the beneficiary. This is a Medicare statement. So you could actually have a private contract or individual contract with a patient. And even with workers' compensation, remember that statement, it said that this does not prohibit you from having a separate contract with the patient. The same thing, this is federal law that talks about Medicare, saying nothing prevents you from having a private contract. And that gets into something called a deferred payment agreement that the provider has with the patient. And this sort of outlines things and outlines, okay, we're going to defer payment. It's not contingent on settlement. It's not something where, it's a lien or letter of protection. But I think you're going to see these be a lot more popular, are deferred payment agreements with the patient. And these agreements could also outline to say that, they understand that they have health insurance, but they don't want to use it. But also that the provider is not in the health insurance program. So those are all things I think you're going to see over the next couple of months. You're going to see more prevalent are some of these laws and some of these other documentations that are needed as far as forms are concerned. So this is, here we go right here. So any claims for medical and healthcare expenses rendered under a letter of protection or other arrangement with the healthcare provider renders in exchange for promise of payment to the plaintiff shall be recoverable for damages regardless of how the arrangement referred to. The following should apply. You have to have the letter of protection. You have to actually show the copy of the letter. All the charges have to be submitted appropriately. The billing and coding has to be done according to medical standards. If the provider sells or has liens, not liens, but basically funds the cases, that information has to be documented. And I think SB 69 is a much better bill as far as like it's laid out better. It's more thought out, I think, anyway. But basically, if somebody funds cases, it's a whole different ballgame as well. Now, I'm not going to get into funding because chiropractors typically don't fund. But it is something where just be aware that funding cases and any type of arrangements that require exchange of money or funding or any of those other arrangements are going to be scrutinized more frequently. Now, under these type of agreements, under a letter of protection or a lien, whether the claimant is referred for treatment under a letter of protection or other similar arrangement, the identity of the person who made the referral has to be disclosed. So this is also something that these letter of protections and liens are going to be different than a deferred payment agreement, which is just between the provider and the patient and doesn't involve the attorney. So again, these are just things as far as education. It is important for you to get in front of your healthcare attorney and decide what's best for your particular practice. But I do think you're going to see deferred payment agreements be a much more frequent and popular type of agreement. Now, Section E is interesting because it talks about how this, can't cause jury confusion, which I think when they get into the weeds with all this stuff, it sort of has to cause confusion because how are they going to know the contracts? How are they going to know the fee schedules? There's a lot of non-disclosures. There's a lot of information that how are they going to get access to? We're going to dive deeper into some of those in a second. But this is a section that talks about that they do want to prevent jury confusion. And I think by the way it's designed, it will cause jury confusion. So nothing in this code shall be construed to apply to limit the right of the plaintiff or defendant to prevent evidence or testimony or both challenging the reasonable of medical and healthcare expenses where they occurred in the future or projected expenses for medical treatment. So this is where it's going to be, okay, we're going to need experts. We're going to need people to go in there and say, okay, what is usual, reasonable, and customary? And so it's interesting because Section C goes in deep into, okay, we're going to use health insurance or workers' comp or Medicare. We're going to use that as a fee schedule. And we talked about how there's contracts, in those contracts, they say they really shouldn't be used for it. But also Section F basically makes Section C not needed because of the fact it talks about, well, it should be usual, reasonable, customary based on the evidence presented. So again, it gets what's presented to the jury. and you're going to have fact witnesses, expert witnesses, but ultimately it's going to be what the jury seems as being reasonable. And that's why it's going to be really important to document well, but also, as we talk about in the end, to make sure your codes are reasonable, make sure that they are in line with other professionals as well. You know, I reviewed a case not too long ago, and basically the chiropractor's bills were $1,500 per visit. I wish chiropractors could get $1,500 a visit, but that's not usual, reasonable, and customary. So at the end of this presentation, I have a link where you could check your fees with other providers in your zip code that could give you more of a ballpark figure. Are you in reason with most other providers? So this is getting into what is usual, reasonable, and customary. What does the science say? What does the literature say? What do the experts say as far as what is usual, reasonable, and customary? And this is the AMA, the people who make the coding and billing codes to consider the gold standard. And this is policy H385-923. The American Medical Association adopts a policy for the following definitions. Usual means the fee that is usually charged by a given service by an individual physician to their practice and patient, their unusual fees. Customary is when it's within a range of usual fees charged by physicians in similar training and experience for the same fee within a specific limited geographical area. And I always like to say there's not one fee for everyone. Basically, what happens is that there's a range, you know, depending on expertise, depending on location, depending on years in practice, you know, so there's a range. And so from that range is you get something that is acceptable, but there's not really one standard fee to say it's $35, $85, $110. Getting down to a dollar amount rather than a range is not really what the AMA suggests. I found it really interesting to talk about where it says in C, a fee is reasonable when it meets the two above criteria and is justified and considered under special circumstances of the particular case in question without regard to the payment that may have been discounted under government or private plans. And so it's interesting, the AMA's definition basically goes against what Section C talks about, saying that, you know, using health insurance rates, Medicare rates, or workers' compensation rates is not reasonable. And we're going to go in deeper why that's not true in a second as well. But the AMA's own definition goes against Section C. Also, RMA takes the position there's no relationship between Medicare fee schedule and usual reasonable fees. Okay, our AMA takes the position that there's no relationship between the Medicare fee schedule and usual, customary, and reasonable fees. Okay, so even if they're using Medicare, the AMA specifically says there's no correlation between the two. This is healthcare.gov. This is the federal definition of usual, reasonable, and customary. UCR, the amount paid for a medical service in a geographic area based on what the providers in the area usually charge for same or similar medical services. The UCR amount is sometimes used to determine the amount allowed. Okay, so basically, you could charge whatever you want, but what's usual, reasonable, and customary to reimburse. And that's where you come into the experts coming in talking about, okay, $1,500 per visit is not usual, reasonable, customary. $200, $250, $300, you know, whatever, depending on the services and the geographical area, there may be a range. And if they fall within that range, then you're like, okay, that's reasonable to me. So this is something where I think you're going to see more people rely on this section E, talking about having experts or having a range of that providers can charge versus an actual dollar amount. Also, one thing chiropractors have very specific protection under is any bill reductions or denials of chiropractic services need to be reviewed by a provider accepted by a review agent by the Board of Georgia. So the Georgia Chiropractic Board has an accepted list of chiropractic review agents. And as you saw at the beginning, I'm one of those. There's probably about 12 to 15 review agents. But basically, the Georgia law states the practice of chiropractic shall include peer review, which is defined by a procedure by which chiropractors licensed in the state of Georgia evaluate the quality, efficiency of services performed by other chiropractors, including but not limited to practice analysis, auditing, claims, underwriting assistance, utilization review, and compliance with applicable laws, rules, and regulations. Okay, so claims adjusters, AI, artificial intelligence should not be evaluating these. These are things that need to be done on a case-by-case basis from chiropractors that are on the review agent list accepted by the Board of Examiners. And anyone who's interested could reach out to Dr. Alpert. He's chairman of the board, and he could help to facilitate how to become a review agent and the qualifications, but there are qualifications for being a review agent. There's also penalties if review agents abuse their privileges or also don't do things appropriately, and we'll get that into a second. But also I wanted to point out, and I've used this before, where we're under special protection as well from the U.S. Supreme Court to protect chiropractors. So this was Wilk versus AMA that provided unique protection to chiropractors against discrimination and restriction of our services. So this is a great Supreme Court, U.S. Supreme Court ruling that we should all know and use if it is something that we're being discriminated against. Now, if it's something where a chiropractic review agent says, look, this is not appropriate, maybe another one says it's not appropriate, you get a second opinion or something, it's probably not appropriate. But also it is something where it should not be people arbitrarily. It shouldn't be a nurse saying, okay, I think 8 visits is appropriate. I think 5 visits is appropriate, or I think $35 is appropriate. So it needs to be someone in the state of Georgia that is accepted as a peer review agent by the Board of Chiropractic Examiners. And this is something I've used many times over the years, and it's helped a lot because of the fact that they've had out-of-state people use it or people not on the list. And when I question it, then automatically they pay the bills. And they say, well, yeah, because we had someone who was not approved review the bills. So remember I talked about that there are also penalties. You know, if the documentation is clear, it can be a board penalty if there's immoral or unprofessional conduct to deny services when there's an expectation of getting better, the patient shows a reasonable rate of improvement, or there's comorbidity factors or the patient's age, frequency of care. So also, I mean, as a peer review agent, there's some responsibility if it's documented to say, wow, that's, it's documented, but also in most cases, the documentation is very, very poor, but also it's important to know that there are certain standards that peer review agents have to keep. It's also not just for acute care, it could be for maintenance care and support care as well, because there's nothing in statute saying once you get into an injury, it only pays for acute care, it pays for all medical necessity care, but it gets all back into documentation. Just like Dr. Basili said, people are going to have to up their game. They're going to have to really document better, do better patient care, better services. And really that's what it's all about, is saying what's best for the patient. Are they better? Fine. If they're better, then just, they're blessed to be better. If they're still having problems, refer them to a medical specialist you trust to be able to get the diagnosis, but also work to your skill set to get the best diagnosis possible as well. So health insurance, again, Section 7C talks about, repricing according to health insurance, but when you sign an agreement with the health insurance, there's a fair exchange for reduced reimbursement, increased business, and timely payment. So when you sign up with, like, just say, I don't know, just Blue Cross Blue Shield, and you sign up and you're saying, wow, I'm gonna be in their provider book, and there's a company around the corner that they all have Blue Cross Blue Shield, you're reducing your fees. You're also expecting to get paid less, but in a timely manner. So to say that you're going to accept a person who doesn't have insurance or may have insurance but doesn't have the means even to pay a copay or deductible, and you're providing services to someone that doesn't have access to care normally or the funds or means to do that, should accept the same rate is not right. There's no more noble purpose than helping an injured victim who doesn't have access to care. That is something where I think I was really disappointed in this law, because it really did nothing to protect Georgians. It really was with other motives. I won't get into that, but I think focusing on what's best for the patient is always important. Sometimes that's chiropractic care and sometimes that's not. But there is a fair exchange here, and that's important to signify. Also, we have a statute with the rules and regulations, which is 12220-3, which saying insurers are not allowed to include most favorable nations clauses in contracts. Now, this is true for insurance companies, but it's also true for other businesses as well. I like McKendrick's, but also, you think Waffle House. Waffle House is the #1 seller of steaks. I'm not going to go to McKendrick's and say, look, Waffle House charges $15. I think McKendrick's, I want to get the same price because, and that's the Fair Nations clause. So it's something where this is a clause and rule I think people need to know about and understand, because of the fact that this also is against what they're talking about in 7C. Under Georgia law, insurer can enter into preferred provider agreement. So providers are given an option. We're not forced into saying we have to accept insurance, but we are given an option and we can do a contract. If you choose to accept an insurance contract and sign a contract and accept a reduced fee for timely payment, then that's great. But also you should accept that for all patients. You shouldn't just say, okay, PIs, I'm not going to accept it. But you need to make that business decision, that decision on your own practice, whether you decide to do that or not. But these are things, all individual opinions, and should not be forced on us. The workers' compensation. So, as I talked about, these are things that are a fee schedule, and it is the only state mandated fee schedule. Now, when you're talking about fee schedule, these are paid within 30 days. If it's not paid within 30 days, and these are guaranteed payments, then there's interest that gets paid. And we talked about the interest schedule later on, but it could be quite significant. Now, workers' comp is not fair to pay for someone who provides services and waits 2 years later. I set my fee schedule based on 2 to 3 times workers' compensation. And that's something I felt was appropriate to say, okay, workers' comp is not a fair fee schedule to extend credit to patients and wait for payment. But 2 to 3 times workers' compensation, in my opinion, would be fair. And that's what I've set my fee schedule as, is workers' compensation. Now, this is something you could get on the state website, and you could go there and get the updated one. The 2025 is not out yet, but it also talks about impairment ratings. It talks about chiropractors doing impairment ratings. It talks about fee schedules, even as an expert witness, $600 an hour, $150 each 15 minutes. So there's a lot in there that talks about with the that it could apply to personal injury. But again, I think the fee schedule is, you're comparing apples to oranges, because of the fact the fee schedule is based on something that is going to be paid within 30 days. Now, the fee schedule and the treatment of care for workers' compensation is nationally under something called ODG guidelines, the official disability guidelines. They have something for workers' compensation. They rolled out a couple years ago ODG for auto injury, which they actually have their criteria, their protocols, what's reasonable, what's customary, when is it necessary to do chiropractic care, when an epidural, things of that nature. And I'm certified by the ODG. I'm also certified by the state of Georgia as a workers' compensation professional, but that was back in 2012. I think they discontinued the program. But basically, it is also important that that statute also not only talks about the fees, but also the treatment as well, too, the treatment protocols. Now, this is an exception to the guidelines. So it specifically says in the guidelines, and the guidelines are very good. If you're not familiar with them, I would recommend getting them. You can get them online. But these publications are guidelines. They're not inflexible prescriptions. I mean, I've been involved with some people where they say it's 8 visits and that's it. Okay, so basically, this is a great document to basically say, look, it depends on the patient. Of course, someone who's an 18-year-old athletic male, is going to have a higher tolerance for injury than a 90-year-old female who's arthritic, overweight, and has diabetes. So you want to take each patient individually, look for different human factors that may cause healing or delay healing, and different factors that may increase the risk of injury as well. So these publications are guidelines, not inflexible prescriptions. They should not be used as sole evidence for an absolute standard of care. Guidelines can assist clinicians in making decisions for specific conditions, also help payers make reimbursement decisions, but they cannot take into account the uniqueness of each patient's circumstance. But that's also why we need to document that. Okay, we need to outline that. If it's not in the records, it didn't happen. So we really need to take the time to up our game and really dive in deep to, okay, what are the factors that may increase the risk of injury? What are the factors that can delay healing? And the ODG does a good job of giving us some benchmarks to use. In cases where medical care is an exception to ODG, the healthcare provider should document the extenuating circumstances of the case that warrant performance of treatment, or including rationale for procedures not addressed in ODG, patient comorbidities, objective signs of functional improvement for treatment conducted thus far, measurable goals, prognosis, expected for additional treatment, and the evidence that support the healthcare provider's case. So it's important to document things. If you do have a problem where they deny care, delay care, or reduce care, spend the time to do a rebuttal. Even if there's really no money involved, I do rebuttals just to fight for it, because also if you're doing the right thing, you want to make sure to fight and make sure that they know that there's guidelines for this, but also it's not prescriptions. They're not inflexible. They do depend on patients' healing patterns, and also the risk of injury and the delayed healing factors that may be presented in the file. And, again, chiropractors, we have to look at the law. So just like I talked about the Wilkes case, we talked about, the federal Supreme Court ruling that gives us extra protection. We talked about the chiropractic scope of practice that also says you can't reduce claims unless you're a chiropractic review agent. But also there's nothing in statute saying that it only does acute care. This is a great paper by Greg Baker, who actually was on the board of examiners here in Georgia, and basically outlines for the treatment for acute care and chronic care. So sometimes chronic care is needed. Chiropractic is the largest drugless profession in the United States to help patients get better without drug surgery and injections. There are a lot of patients that don't want drug surgery and injections. And also, if they're getting injections, is that really fixing the problem? So if you get a radiofrequency neurotomy, did that fix the facet joint? No. All that did is block the nerve to the pain area. So this is an example I use. This is a great model. It shows the capsular ligament. So if you have a tear in the capsular ligament and they have instability, we do motion x-ray here. So say that they're showing that there's interarticular joint damage that causes ligamentous instability, and they deaden the nerve to the joint. Did that fix the problem? No. But the patient may have gotten pain relief because the nerve was ablated, but did that really fix the problem? No. Long-term, it's going to cause post-traumatic arthritis. So chiropractic can also be used for chronic care as well, but you have to document it. The law is very clear in Georgia that we could fill out certificates like any other healthcare provider. Also, we have a responsibility as a primary care healthcare doctor to refer to other providers and medical specialists. When in doubt, refer it out. It never hurts to have a trusted group of medical professionals that you would go to yourself, you would send your family to be able to use to help with patients, because chiropractors cannot do it all, but we are primary care doctors where we can help to get patients the best care possible. Also for impairment ratings, it specifically says on page 23 that chiropractors can do impairment ratings. So I encourage providers to take the time. This is a great opportunity to sort of dive deeper into what's going on in our profession, but also dive deeper into getting information about the scope of practice of chiropractic and also different types of injuries. Now, there's other problems with Section 7. There's a lot of non-NDAs that can be applying, and it's going to be difficult for them to get policy and payment fee schedules. Also, treatment guidelines are going to be difficult sometimes to get. Also, HIPAA violations. Dr. Basilia pointed this out numerous times that it could be a HIPAA violation. Also, if patients don't want to disclose it, that's one thing. But also, I think there's also some antitrust aspects too, because of the fact that, if say that Wellstar, or I won't use any names, but just say some hospital system, that they negotiate a great contract with an insurance company, and that contract is double what a small individual provider does. Okay, well, they're rewarding a group that negotiated a contract, and that contract was based on that they have a larger footprint, they have more area. But again, that sort of is an antitrust thing, because that increases the competitive advantage to other groups, professionals, rather than the smaller providers. So I think you're going to eventually see some antitrust violations as well, because of the fact that they're also doing the most favorable nations. They're getting a contract, an agreement that is accepted by a provider, an insurance company, and they're using that for their own benefit. So what to do? There's a lot of information we covered, and I tried to cover a lot of information in a short period of time. But, if you have any health insurance contracts, review them. Decide, is it worth being involved in the health insurance contract? If it is, talk to your attorney or talk to people about, okay, what do you need to do to with these contracts. But I would encourage you, if you accept health insurance and it's somebody who's involved in a car accident and you normally would accept the health insurance, I would say just accept it like you would any other health insurance. I wouldn't have one policy for one and one for another. If you want to review your fees, fairhealthconsumer.medical is a great place you could check your fees. They check on geographical area. I had one insurance company that questioned me about my fees, but before the deposition, I went to this site, and it turned out the fees were, higher than what I was charging. And so during the deposition, I pointed it out, and I said, thank you for bringing this to my attention, because, I was voted 2019 chiropractor of the year, and I shouldn't be shortchanging myself. And so I actually increased my fees because you gave me the encouragement to go look up the fees, and I'm really shortchanging myself. So look up the fees. Is it reasonable for your area? Review patient contracts, form, and agreements. dive deeper into facet syndrome, disc herniations, brain injury, PTSD, anxiety. Focus on good patient care. It's interesting because money does not cause success, but success results in money. So focus on being the best provider you can, give the good patient care, and you're going to find everything will flow very nicely. But review your treatment paradigms, review your relationships, your imaging guidelines. One thing I see a lot as review agent is that just the overutilization of MRI. Everyone has a bulging disc, but yet then they neglect facet syndrome and they focus on maybe the wrong treatment paradigm. So really focus on getting a good anatomical diagnosis. What is usual, reasonable, customary? In fact, a couple of years ago, I wrote a book and I outlined some of these things. And anyone who wants a copy, just text me or give me a call. I'll send you a copy for free, or stop by my office. I'd love to show you around and I'll give you a copy. But I outlined the different anatomical causes of pain. So focus on great patient care, anatomical diagnosis of pain, and also reputable medical providers. So if you wouldn't refer your family or friends to them, I wouldn't refer to them either. Stay informed about what's going on with this new legislation. Consult a healthcare attorney about things. Nothing in this presentation is advice or recommendations or legal advice. This is all just for education purposes. Call Dr. Alpert if you're interested in getting involved with a network of chiropractors, best standards for chiropractors, evidence-based chiropractors to help patients get better. I think there's going to be a need for chiropractors to treat patients on an evidence-based practice. And that's Dr. Alpert's phone number if you have any patients that need to be seen in the Atlanta area. He also takes those calls. If you're a provider that want to be in the network, give them a call. And then also, if you have questions, on the first slide is actually my cell phone number. And with Jen, with All Things Neuro, I thank them for having me here today. But also, I'm going to present all the slides to them, and they could actually email the slides to anyone who requested.
Awesome. Now, are you going to be autographing that book when you send it to people?
Sure. Anybody who wants it.
Yes. I need to bring mine back in then, get it documented. So thank you. This is amazing. I know I took away a lot, and we'll definitely be sending this out to anyone who's interested, as well as having some AI notes involved as well. If you have any questions, let's go ahead and use the time we have for that. If you can just keep yourself muted, but then raise your hand, I can call on you. Do you want to unshare your screen, Chris, so
Yes,
that we can see everyone a little better?
There we go. Is that right?
I still see your screen. There we go. I think you have to unshare. Okay. Are we seeing? I see Zoom. I think we're looking at another screen of yours.
Maybe could you make me not the whatever it's called, the host?
Let's see if I can stop. No, I don't know how to do that. I'm not seeing any. I don't see
How's
any.
that?
I still see. Let me see if this helps. That didn't help. That's okay. I'm not seeing any questions, so that means you are very thorough. Does anyone have any last minute questions? We got 6 more minutes of his time. I know you spent a lot of time on those slides, so I really appreciate that you did that, and hopefully, a lot of people were able to glean away. If anyone wants to just make any comments or takeaways, I think this would also be a good time.
I have a question. Chris, can you hear me?
I can.
Who are you?
I am Steve Barnett. How are you?
Thank you. Great. What's your question or comment?
Chris, you talked about if you're in a Blue Cross Blue Shield network and your patient has Blue Cross, go ahead and use it. But what happens if your patient comes in, hasn't met his $5,000 deductible and doesn't have $80 for copay, and then tells you that I elect to be a cash patient because you can't waive his copay, nor can you waive his deductible. So what do you do at that point?
So that's also where the delay of payment, or just like if you get braces, like say a child gets braces, you have them sign an agreement, or even like a student loan. So a student loan, you get the services, you get your degree, and you pay at a later date. So having those deferred payment contracts is going to be essential. Um, I've been using them for a while.
But
I
if the
think it is
patient,
actually better practice to have patients sign an agreement and be aware of things than just send an attorney a lien or letter of protection. So I think you will see that there's going to be less need for that, and because of the fact that there's going to be a lot more things, it's better to have that agreement with the patient and just say, hey, we're going to defer payment or delay payment, but also ultimately you're responsible. But I think you're going to see that delay in payment form going to be essential.
okay, so you would not, obviously, you would not file their health insurance. In the case of a question with you being a provider for Blue Cross Blue Shield, and I know that you're not, but if you were, I'm sure you would have signed an NDA agreement, which actually prevents you from disclosing what your agreed upon rate is with Blue Cross Blue Shield. If anybody wanted to get that information from your office, you would be violating your NDA, and for fear of being removed from the network, you probably would not want to do that.
Yeah, exactly. I would, there's going to be a lot of need for healthcare attorneys, but also if you normally accept health insurance, do it. Um, if the patient doesn't have means to pay, and then that's where you would have them sign that document just saying they don't have means. But the more you document it, the more sort of honest you are, the more you document it, the better it is. But I mean, do things that are logical. So if it's presented to a jury, they would say, okay, that seems reasonable. So, and I think ultimately that's what you have to do. And, I've testified live at trial 50 or 60 times and so many depositions and things. And I always, when I do things, I think, what if that was presented at a trial, what would, um, what would the jury think? And so it's always good to just try and take the high road, but also document things. But if patients don't have means to pay, document things and just say, hey, they don't have the ability, there's a $5,000 deductible. But that's something each individual practice is going to have to consider. I weighed all the options and decided not to be a member of any insurance company.
And lastly, it's not a question, but I know how many people work so hard to defeat SB 68. So I saw Mike on the line. I'm driving, so I really can't see anybody. But I want to thank Mike and Kenny for their tireless work in trying to defeat SB 68. And I want to thank you for spending so much time developing, the knowledge and sharing it with everybody. And Jen, of course, for helping put on the program. So if I could clap, I would, but I'm in traffic and I got both hands on the steering wheel.
Well, cheers to you as well, all you've done over the years. So thank you, Dr. Barnett.
Just want to emphasize that this really is a community, and the more we can help each other out, the more improved outcomes we're going to get for the patients that are injured. And it does take creativity. It takes a lot of minds to navigate the ever-changing industry that we live in. This probably will be one of many changes that are down the road. And I think one of the biggest takeaways was providing quality care, upping your game on notes, and really doing your due diligence of what's appropriate medically. I think that at the end of the day is what's really going to count. And for us to find people that we're working closely with and build relationships so that there's a trust and that we are all doing it for the right intentions. So I think we're going to wrap this up. I don't see any other last minute questions. And just again, want to thank you again, Dr. Connelly, for taking the time. And hopefully you will be able to speak again. You're going to be speaking in one of our upcoming lunch and learns later this summer for attorneys for our improved outcomes. So always grateful that you've been very generous of your time to provide education, and the Academy is a great example of what you did. Did you talk enough about what the Academy is about and how people can get information? I know you weren't trying to make that the point, but I do think that's a valuable resource where you funnel a lot of education for especially chiropractors. If you could just briefly talk on that, and then we're going to wrap up the call.
Sure, and anyone reach out to Dr. Barnett. He's our new president, but basically it's evidence-based care and helping providers excel through clinical excellence. And our philosophy is, focused on good quality care and the success will follow. And so it's all about, like you just said, focusing on doing the right thing, upping our knowledge. For years, even Facet syndrome, people said, what is that? I wrote a paper that was published in a medical journal in 2005, 20 years ago, and it was about Facet syndrome. And people are like, what is Facet syndrome? So the Academy is all about helping providers be the best version of themselves.
Love it. Well, thank you again. Thank you everyone for taking your time on a what is today, Thursday evening, when you could be with your families, and enjoy the rest of your evening, and we'll be in
Thank you
touch.
very much, Jen. Thank you.
Thanks, everyone.
Good night.